Welcome to my live question and answer session, viewers. My name is Suhail Ahmed. I'm an immigration lawyer in the UK. And next couple of minutes, I'll be with you to give your live question and answer on Facebook. Enjoy the show. Viewers, first I'll give you some important awareness message for the viewers who is watching this live video on Facebook or in YouTube. Many people spreading messages through the different Facebook group on YouTube and in different platforms that in UK from next January 2020, the student visa and work permit is going to open. I know many people are very curious to come to the UK, but when you are too curious to come to the UK, you will fall on a trap of fraud. The first of the statement, what is spreading in different media that a work permit is going to open and student visa is going to open from January 2021. This statement is not correct. This is the starting point. Student visa never been enclosed in the UK. Work permit never been enclosed. So it's not going to be open something which is new for non-EU citizen. It's not a new opportunity to come to the UK. Student visa was open previously, still is open, and it will be open in future. Work permit was open before then today. Right now, work permit is open and it will be open in future. So this is a way to attract more people in to increase more follower, to get them biased to them that work permit is going to open, student visa is going to open. This is not correct. From time to time, different government, different home secretary, when they come to the power, when they need, they reform the immigration policy. As a part of this reform, the Home Office is going to introduce new immigration rules, which is reform the existing immigration rules, and nothing else more than this. Student visa, in terms of student visa, nothing has changed apart from 2 years work permit after post-study work permit, which used to be prior to 2012. So student visa is going to be open from January. This statement is not correct. In terms of work permit, again, a little bit reform has been done in work permit, which will come into force. That is the salary threshold, which was 30,000, is come down to 25,600 pounds. Residence number test has been removed. The 70 point, which is replaced by existing tier 2 general work permit, which also requires 70 point. So anyway, if you want to come to the UK under under the immigration rules, don't fall in trap of fraud to different agency, different people. Be aware and always be aware and follow the immigration rules. You can choose it directly. You can read it from the Home Office website. Keep on update. Speak to your immigration consultant, qualified and experienced immigration lawyer before you make any decision. Today I'll give you live question on Facebook, and many people send many messages. They send a question on Facebook via my email. So I'll go through it. I'll not able to give all answer, but some important question which might be relevant for many people, and I'll give your answer on live. I'll not mention your name, just I'll recite your question and then I'll give your answer. So first question, ask me someone. I'm married to an EU national in January 2016 in UK. I have 2 kids together with the EU nationals. Unfortunately, we are not living together now. Can you please tell me what I can do? Thank you for your question. You have right under EU law, although your relationship with EU nationals has been broke down. So you have 2 rights under, because your kids is EU nationals as well. So you have one right under because of the case, which is called retained right of residence under immigration regulation, under regulation 10. that if you are a carer of EU national, EU child, you have retained right of residence. Secondly, your relationship from 2016 to 2020, which is more than 3 years. So even though if you don't have a child, if your relationship break down with a EU nationals, in that case, you will have retain right of residence under EU regulation 2016, and therefore you are eligible to apply for settled status once you completed for 5 years. That's what right you have. Secondly, under the Zambrano case law, again, this is a case law from the European Court of Justice, that if you are a carer of a EU child, then again you will have retained right of residence. So you have three types of retained rights of residence. First one, you have a kids, which is EU national. Secondly, you are a carer of a kids. This is, and third one, your relationship lasts more than 3 years with the EU nationals, and you haven't divorced, both of you. None of you take any. I mean, your relationship that until that decree absolute, you can apply for settled status. So there are three ways you can apply for settled status in UK under EU law, as well as same policy was adopted in EU settlement scheme. Thank you very much for your question. Next question. I and my wife applied for ILR. I don't live with my family. We applied same time, but we got different appointment date. I was first one who attended the appointment first, then my family, my wife. After a week, they got confirmation email of granted ILR. I'm still waiting for it. What shall I do, and what's the reason is delaying? Thank you for your question. This is something is very familiar to me. The reason is delaying probably your partner case worker was she got or he got your case and early make a decision. Your case probably in different case worker who is dealing with late, because most of the staff is working from home. Unfortunately, they are not able to communicate each other in terms of which application to make a decision first. So you don't have to do anything. Wait for 6 months, and then if they don't respond to you, then you can remind them about it. Next question. Dear sir, I'm an asylum seeker from 3 years, but not yet get the decision. And then you ask me, I have two questions. One, if I want to go back to home country, how many days will it take to get permission to return related document? How long this period gonna take? Secondly, if I get my own ticket, then how long it will take? It is necessary inform a home office, or when I'll get whether any problem if I want to come back to the UK. First of all, you cannot go to your home country. You shouldn't go to you can, but you shouldn't go to your home country. I'll come first. Your first line of question, you asked me, I'm an asylum seeker from 3 years, but not yet get decision. Unfortunately, 3 years is too late. I'm not sure why you haven't get a decision yet. Asylum claim normally within a year they shorted. Even 6-8 months normally you will get a decision for asylum seeker. Unfortunately, if you are delayed, highest 1 year or 2 years take, but I'm not sure why it takes so long. I'll advise you to speak to your solicitor if you have one. Ask them, contact to the home office first to find out whether they already make a decision, because 3 years is not seems to be everything okay. I think they already make a decision. And then they send you a decision either to your solicitor or somewhere address where you was registered with the home office, and if you haven't received the letter. So this is the case, I believe. Otherwise, 3 years is not a right time, because normally asylum decision come within 1 year or highest 2 years. So have a look, find out whether they make a decision or not. The second question, you want to go back to your home country. If you seek asylum in the UK and if you decide to go back to your home country, you cannot come back in the UK again, because when you first of all, when you come in this country, seek asylum, to the and ask the Home Secretary that you have a fear of prosecution because of your sex, because of your religion, because of your opinion, because of your political membership of a political party, because of your color, because of your skin. And you ask the Home Secretary to give you to recognize as a refugee. That's the reason. Now, if you want to go back to your home country, that means what? That means this you don't have any fear. So if you don't have any fear, you will not have any. You will not get any asylum in anywhere in the world, because under Article 1 of Refugee Convention 1951, this is the definition that you must have a fear. Now, if you had a fear, if you have a fear, then you will not go back to your home country. That means either your claim was false, or you had a fear, but now everything is right in your home country, so you can go back. So in that case, you can go back to your home country, but your ground of asylum will be end. You cannot claim asylum in the UK, and you will not have a second question. You ask me that when you will come to back to home, will there will be any problem to come back to your home country? Yes, you will be a problem. First, you don't have visa, right? You claim asylum, it doesn't mean you have a right of you have a right to return. You don't have anti-clearance visa or residence card. What the card they gave you, maybe it's a temporary, which is only you can stay in the UK. So if you go back to your home country, you will not able to come back to the UK. So change your decision. Still, if your circumstance has not changed in your home country, if you don't have fear, you can go back. That's a good decision if you want to go back to your home country. But if in terms of asylum, you will not get anything. So if you go back to your home country, your asylum will end here. So thank you very much for your question. Next question. Dear sir, I applied online 6th of August 2024 PLR. Even since then, I have PLR. This term is not familiar with me. I have not received any kinds of information or email from the Home Office. I tried to call them several, no luck. Please, is there anyone can help? August, you make an application, and this is now November. Under the current circumstance, it is very you are chasing the Home Office very early. At least wait for 6 months, and then if you don't get any response, then you can contact to the Home Office. And because current circumstances is exceptional, Home Office most of the staff are working from home. It's lockdown going on, so you should generally wait longer time than the normal time. So at least wait 6 months. After that, give a reminder, and then if you don't get a decision, you can chase the Home Office. Next question. Currently, I am on tier 2 and furlough, receiving only 80% of my salary. My ILR is due to next month. Would it be an issue while applying for ILR, as I am not satisfied the minimum threshold to get ILR? Very important question, and I think it is important for many people. I'll give answer, and it is relevant for those applicants who want to invite their spouse from overseas, because you need to satisfy the financial requirement, £18,600, or those who want to apply for ILR in the UK on the tier 2, you need to be satisfied the financial, your salary, which is 35,800. So it is important, all of you, because furlough scheme extended up to April. I have already posted a video, and today I'll give you this question is very important for many. So first question, if you get 80% of salary, which is below 35,800 pounds, or which is below 18,600 pounds, what is the immigration policy? Because you are, for example, you are earning only 18,600 pounds. This is an exceptional circumstance. Home Office and the Conservative government, the Chancellor, is very kind to these people, to their citizen, as well. At the same time, they show their sympathy to the immigrant community as well. So prior to that, during the first lockdown on March April, they update the immigration policy, that is, due to the lockdown or furlough scheme, those people who earning 80% because of the furlough scheme, the Home Office said, we will consider that you are receiving 100% of your salary. For example, someone want to invite their spouse from overseas, and they earn £18,600, right? When the lockdown started, his employer put him in furlough scheme. Now he's receiving only 16,000 because his salary is he's getting only 80% of their salary. So therefore he's receiving only 80% of his wages, £16,000. Now the Home Office said, we will consider that you are receiving £18,600 despite you are receiving £16,000. So, dear brother who asked me this question, that you are in receipt of 80% of your salary, it will not be a problem for you to get ILR. Probably you are receipt of £32,000, but you need £35,000 800. The Home Office will consider that you are in receipt of £35,800. The second issue is many people lost their job during the first lockdown period, and there was in employment, they are used to get the salary £18,600 or £35,800. Therefore, they were eligible to apply for ILR, or they were eligible to invite their family member, to their spouse, to their children from overseas under the immigration rules. Now, what they can do, because they don't have any job right now, the Home Office said, if you were satisfy the financial requirement prior to the lockdown or prior to the coronavirus pandemic, they will consider now that you satisfy the financial requirement despite you don't have a job right now, you don't have any earnings. So this rules and this update immigration rules is very kind. It shows the sympathy and support to the immigrant community, same as like the Conservative government, the Chancellor show their UK residents and to their citizen. Another important, also it is relevant, many people who are limited leave to remain, especially our immigrant community, many people who got limited leave to remain. Now, a confusion, it was at the beginning and again during the second lockdown, because many people came in this country after the first lockdown. There is a confusion whether, I'll come back after a short break. Right. Many people, there is confusion whether limited leave to remain holder can get the furlough scheme 80% salary, the furlough money, because whether this is a public fund or not, because your BRP said no recourse to public fund, and this money you are getting from the government, from the HMRC or from the Chancellor, and you are not working. The Home Secretary and Home Office and the Chancellor clearly published a policy that furlough money is not a public fund. So if you are in limited leave to leave holder, if your BRP doesn't allow access to public fund, no recourse to public fund, still you can claim the furlough money, because this is not a public fund. So again, if you received of 80% furlough scheme money, the question is whether it will be a problem, whether should I tell the Home Office application form that I receive public fund. No, this is not a public fund. It will not be a problem for you, because Home Office published the detailed policy where they confirm that the immigrant limited leave to remain holder, those who has got access to public fund, they can claim this furlough money. I also would like to invite and inform my viewers and followers that many people has lost their job. Their circumstance has changed, their income reduced due to the first lockdown, second lockdown, and coronavirus pandemic. Now, you don't have access to public fund. You don't have because your BRP say no recourse to public fund. So what you can do, you are struggling to pay rent, you are struggling to buy food for your family. I want to say that furlough scheme again extended up to March. The chancellor and the government is show their sympathy. They are very kind to their citizen. The same way the chancellor and the home secretary, the home office is, in my opinion, is very kind to the immigrant. Now, if you want to apply to change the condition of your BRP, that exactly I'll tell, that is your BRP right now not allowed to recourse to public fund. But if your circumstance has changed due to the lockdown, due to the pandemic, you can apply to the home office to recourse to public fund, that is access to public benefit. This is very important information for those who need actually public funds, those who need universal credit, child benefit, housing from the local authority. If you struggle to pay rent, if you struggle to buy food, if you're struggling to survive in the UK, you can ask the home office to change the condition of your BRP and to allow you to access to public fund. Now, you can make an application to the home office to change the condition of your BRP. This application is a bit technical because what the home office want that your earnings is less than your the spending. So your income is less than your earnings. And then they will find out that whether you are a destitute or not, because the basic principle is you have to be a destitute if you want to apply for or get access to public funds. That is, you have to apply to the home office that you are a destitute. Now, the legal definition of destitute, who is a destitute? The question is, now, those people or those person who cannot pay their rent or who cannot pay to buy their food, this is the group who can tell that I'm a destitute. So what the home office want? Home office want the proof how much you earning. So how much you earn, you need to provide your payslip, P60, bank statement. So for example, you earn £1,000, and then the home office want to know that how much you spend for your home, for your family. So including your rent, you need to provide your tenancy agreement. You need to provide your expense, including petrol, car insurance, utility bills, how much you spend in Asda, how much you spend in Tesco, how much you spend in Primark for buying clothes, food, accommodation, transport, for how much you pay in school for your children, lunch, everything. Everything you have to tell, so how much you earn. Then the home office will assess your application. In the form, there is two part. One part is your earnings and one part is your expense. And you need to, there is a table in the column, you need to write every single information. And then the system will automatically will show, or they will assess your application. Yes, this person earnings is less, income is less than his expenditure, so that he is a destitute. Accordingly, home office will grant your application to give you access to public fund. And many people, many application I'm telling you on air, I made plenty of application during the first lockdown. Every single application, alhamdulillah, had been successful. So if you need any help from the government during the second lockdown, from the chancellor, from the HMRC, make an application to the HMRC to change condition of your BRP. You will get access to public funds. Thank you very much. Also, for fee waiver application, I discussed same rules apply if you need any fee waiver application, because right now home office fee £1,054 per application plus an HSV which has been increased nearly £1,560. So it's a huge amount of money, nearly £3,000 plus the solicitor cost. Not everyone can pay. So if you need any help, if you need to make an fee waiver application, you can make a fee waiver application, ask the home office to give you a fee waiver, and then you don't need to pay any home office fee or the NHS fee. At the same time, if the home office accept your fee waiver application, you will get access to public fund. This is the main advantage. So if you need help, make the application in advance before your visa expire, and then you don't need to rush. Once you make the application, wait for the decision. Even if your visa expire, your leave to remain will continue. You will not be an overstay under Section 3C of 1971 Act. Viewers, this is a live question and answer session. If you have any question, I leave your answer on live. You can leave a comment, and please share this video for the help of our community. I'll come back after a short break. Viewers, this is now I'll take question. Many people ask question on live. So first question, Afjal Badshah, do you deal with tier 4 visa? Thank you, dear brother Afjal. We don't deal with tier 4 visa. We provide legal service. If you need any help in terms of make an application to the Home Office, or if the Home Office refused, if you need any solicitor to provide help to support to make an appeal, we can provide legal support from our team. As excellent solicitor where I work for, and we have a very good team of immigration lawyer. We are happy to help, but we don't provide any agency service. I don't have any connection with any university. I can support only legal side. So that's what your answer is. Next question. Primson Stanley, a British citizen, sponsor my daughter into UK. Please advise. Thank you very much. If anyone who is a British citizen, if you want to sponsor, I need to know on what basis you want to sponsor. If you want to sponsor as a fiancé, that is a different criteria. You need to satisfy the full requirement, financial requirement, accommodation requirement, relationship requirement, and English language requirement, what has to be satisfied by the applicant. So if you want to just apply someone, sponsor someone for visit visa, that is different requirement. So if you make it clear, I think I will able to help you in live this video. And next question, Johanna Daira. You asked me, I called Home Office about my biometrics since 31st of July 2020, and I want to travel my dad. I want to go to funeral, make that escalate, and last week I received the email for the UKBI contact center. What is going on next, please? Very unfortunate. I'm very sorry to hear the news that your dad passed away and you want to go funeral. You haven't heard anything from Home Office. I think in that situation, you need to act very quickly, very strongly. If you write letter to the Home Office in this situation, trust me, Home Office are very slow. They will not respond to you. Or if you email, I'll advise you very important way you can deal this matter. Tomorrow, call to your local MP, his or her secretary. Make an appointment, explain your situation, and tell your MP to write a letter to the Home Office or send an email. And normally MP write, their secretary write, they will send an email to the Home Office and you will get a response quickly. Within a month, you will get a response. So my advice to you, contact to your local MP, of call to her, their secretary, whoever you are, call to her or him, and then make an appointment or explain your situation over the telephone now, because lockdown period, so he may not see you face to face. So explain it to him, and then ask him to write a letter. They will write a letter and you'll get a response from the Home Office. Riyaz Muhammad, Assalamu alaikum assalam. Kids born in India before I become British. 6 years old, not having continuous residence, once away for 1 year, 3 months. Can I apply for naturalization, my kids? Thank you, brother. No, you cannot apply for naturalization for your kids because your child born in India before you become British citizen. First, you need to bring them over here, and once they complete 5 years, then you can apply for naturalization. And secondly, you also raised me issue that 1 year, 3 months is a break. So this is an issue because you need to satisfy the residential requirement in naturalization application. That is, you must not be out of the UK more than 450 days last 5 years or 90 days last 1 year. This is the residency requirement for naturalization or ILR. So in that case, as he was out of the UK for 1 year, 3 months is a break of residence requirement. So you cannot apply for ILR for him as well. Excuse me, for naturalization for him as well. Next question. Ali Ibrahim Abu Ridwan. Salam, brother. Quick question. Yes, brother. I am here from 2014 as EEA family member, then separated in 2016 and got human rights Article 8 because of my son was 26 month expired on 2019 March, but I did apply in January 2019. So from that until now waiting decision. Brother, I think in 2016 you did a big mistake. Why you make an application for under the human rights? You didn't need this application that time, because if you have a child with EU nationals, you have retained right of residence. This was my first question. You would had a retained right of residence, and secondly, you have also retained right of residence. Alternatively, because you had a wife, you had a partner, or whatever it is, you had a relationship, and your relationship, if last more than 3 years, you would have had a retained right of residence. So I don't know why or who advised you to make a human rights application, because human rights application is a different regime, is a regime for UK national law, but you wasn't under the EU law, which is more easier. Life was more easier under the EU law. Still, you may have retained right of residence under the EU law and EU settlement scheme. Have a look. I'll come back after a short break. So, Brother Ali Ibrahim, I think you should speak to a solicitor right now. Still, you may have retained right of residence, which is more easier life than a UK domestic law or UK human rights law. So have a look, all the document, and I think it is better for you to see a solicitor to speak about your circumstance. Yes, Ali Ibrahim, brother, please see a solicitor. I think it is important. Maybe you will get a retained right of residence. It is more easier, and someone can help you. I explained already. My first question was retained right of residence. So there is two way. One way, you, because of your child, you could claim retained right of residence under the EU settlement scheme and Regulation 10 of EU Regulation 2016. Second way, you can also claim retained right of residence because your wife, your relationship lasts more than 3 years. You are separated. So some reasons. So again, you can claim retained right of residence. So speak to a solicitor, brother, with all your document, and someone might able to help you. Next question. Bine Anam Jangra. Apology if I cannot pronounce your name correctly. You are write me a very long question. But I'll go through. But I appreciate if anyone asks question, please write briefly as much as you can. Dear sir, I have been in London since 2009, but after 2011, I living in here illegal in 2011. I apply asylum, but they refused in 3 times. Police caught me 2 times. They gave me ticket last time. But now I have a EU girlfriend and 2-year stepson. we know each other since June 2019, and I have all chat on Messenger. And from 2020 July, we're living together, and I want to get married with her. Do you have any advice for me, please? Bine, Mr. Jangra, yes, you have some right under the EU settlement scheme. You can apply under the EU regulation. You can apply. You cannot apply right now as a EU family member, but as an extended or dependent family member, you can make an application, but you need to provide evidence of dependency, so evidence of your relationship. So if you can prove and provide all these documents, you can apply to the Home Office for pre-settled status or EU residence card. But December ended, so I think it's better for you to make an application under EU settlement scheme. That is, you are a dependent family member of EU nationals for pre-settled status. But you need to provide lots of document. They provide document that you are living together, tenancy agreement, utility bills, joint bank statement. If you are financially dependent, it is very important. You need to provide evidence that you are financially dependent on her. This is what you need to provide evidence. I think you don't have much time. It is important to contact with an experienced lawyer and speak to your matter. So whatever you want to do it before December. That was my advice. But yes, you have some sort of right under the EU settlement scheme and under EU law. Riyad Ahmed, thank you, brother. Thank you. Ali Ibrahim Abu Ridwan. I got wrong advice that time when we separated with my wife and applied for asylum, and they refused an appeal and they gave me Human Rights Article 8. Brother Abu Ridwan, still you may claim a retained right of residence. Please speak to a solicitor. Please speak to an experienced lawyer about this matter, because your child is a EU national. You had wife who is your divorce not been completed, so still you can claim retained right of residence. Even if you claim retain of right of residence right now, you may get pre-settled or settled status. Brother, speak to a lawyer. Someone might be able to help, because this regime is more easier. EU law is more easier. EU human rights, the rights under EU law is more easier. Right under domestic law is very difficult. Riyad Ahmed? My daughter, 2 years old now, born in India when I was on ILR, not British. She is here from 3 months. Rules say if British child born outside the UK, we can apply for national. Rules say if British and child born outside the UK apply. Not sure for ILR parent child. Yes, brother. I'll clear your confusion. Right. British Nationality Act 1981, Section 1, Subsection 3, Subsection 7, which is relevant for you. Under Section 1 of British Nationality Act 1981, if someone is British citizen or settled in the UK, if any child born here, the child will automatically be British citizen. So if anyone have British citizen, if anyone who is a British citizen or settled in the UK, if the child born in the UK, British citizen. But if someone is British citizen and child born outside the UK, the child will be British. But if someone have ILR but the child born outside the UK, child will not be British citizen. So this is the difference. So if you have ILR and if your child born in the UK, then your child will be British citizen. But if your child born outside the UK, your child will not be British citizen. Okay, so I hope it's clear for you. Have a look, Section 1 of British Nationality Act 1981. Your confusion will be clear. If you need more help, contact me in my office, and that someone will help you explain you over the telephone. Ali Ibrahim Abridan, many thanks, sir. Thank you, brother. I appreciate if you can call me brother rather than sir. I appreciate. Can you give me experience solicitor number? I cannot give on the air, brother. I think this is something you need to help yourself. Bine Anmol Jangra, where are you based on? Because I want to apply as soon as possible, brother. I have office in London. I have office in Milton Keynes as well. So if you want to contact with me or with my office, please go to my Facebook page, and there is a telephone number starting from 02 or 02. Call them tomorrow and ask for an appointment with Mr. Suhail. So if you make an appointment with me, then I'll see you. Or we have also more lawyer as well. So if you need any help, I have a telephone number in my Facebook page. So contact them. Alternatively, you can send an email. I have an email address, info at ukvisa immigration/visa.co.uk. You can email me, and I will reply to your email. So visit my Facebook page or my website. Thank you very much. Riyad Ahmed Soth said, thanks, brother. Unfortunately, brother, Stephen George, 10 years not registered. What's the option? Stephen George, where you been after a long time? You make a comment or ask a question. Before you was my regular viewers and make a lot of comment. 10 years not registered. What an option. What an option. I think your question is that I'm living in UK for 10 years, but not registered. It's not clear to me, but what I do understand, you are looking for something about human rights, private life, Article 8, or continuous residence 10 years, whether you're eligible for ILR, indefinite leave to remain. Yes. If you are not, if you live in that UK for more than 10 years or 10 years, but you are not, but if it is not a continuous residence, you cannot apply for ILR. Okay. Second one, in terms of human rights, there are 4 circumstances where you can make an application. You can claim human rights on the basis of private and family life under Article 8. Article 8 have 2 parts. One is private life, one is family life. Family life is basically relationship with a family member, with son, with a wider family member, with brother, with mother or parents. And this is how family life are. Private life is different than family life. What is private life? Immigration rules say there are 4 circumstances where someone claim private life. Someone claim leave to remain on the basis of private life. So what are these 4 circumstances? These 4 circumstances, basically, if you live in the UK certain time of, if you spend certain times, then you can claim leave to remain on the basis of private life. It is very important for many people, even confused, or even they doesn't have this knowledge. What is actually Article 8, private and family life? Private life is 4 circumstances you can claim private life. First, if you live in the UK, if you're under 18 years old, and if you live 7 years before you turn 18, you can claim a leave to remain on the basis of private life. First one, 7 years rule. Second rule, if you are under 25 years old, and if you spend half of your life in the UK, that is more than 12 years, 6 months, or it depends on how long you are in the UK. If you spend half of your life, more than half of your life, you can claim private life, limited leave to remain on the basis of your private life, which is called half-year rules. The third one, 20 years to rule, irrespective of your age. If you spend 20 years in the UK legally, or you don't have any document, I'll not tell illegally, okay? If you don't have a continuous residence. So as soon as you can prove that you are in the UK for more than 20 years or more than 20 years, you can claim leave to remain on the basis of your private life. The fourth one is very technical and important. Many people could qualify or can qualify or may qualify for fourth one. Fourth option for leave to remain on the basis of private life is not a duration, how much time or how many years you need to UK. This is very technical term. If you can prove that you will face significant obstacle on return of your home country. You can claim human rights claim leave to remain on the basis of your private life. Now, what is significant obstacle is very technical. This term actually explained by the Court of Appeal in many cases. I cannot tell you the details here, but I'll briefly tell what is significant obstacle. Significant obstacle is those obstacles which you cannot overcome on return to your home country. For example, you have a partner who cannot speak your own language. You have a cultural barrier. You married with a person whose culture, whose religion is different from your own culture, from your back home culture. This is a significant obstacle. Even in one case, the court accept that unemployment, you will not get a job, prospects of employment even itself a significant obstacle. So what is significant obstacle is very wide. It depends on person to person, country to country, culture to culture, depends on your circumstance. If you're wise enough, speak to a lawyer if that whether your situation, your circumstance is a significant obstacle or not. An experienced lawyer will advise you, who is experienced on human rights, who is experienced on private life, who is familiar with the case law in relation to human rights. Viewers, I will not take longer time. Just I will have a look at one question who asked me on live again. My friend my friend going to apply tier 2 visa with wife and son. Can he include his mother, 65 years old, also as a dependent? Thank you, brother, for your question. Under the immigration rules, part 7, part 8, appendix FM, and now they introduce new rules for point-based system. Those who are in the UK under the point-based system, they can invite their family member to come to the UK to join with them. Now, who are the family member? The definition of family member is their wife or partner in a durable relationship, their children under 20 years old. If over 21, they have to be dependent. Only those people are family member. Parents is not a family member. Therefore, he cannot bring her under the immigration rules, under the as a dependent of a point-based system applicant, unfortunately. However, once he bring their family member, there is a route which is available. Once he get ILR, then he can, or become a British citizen, then he can apply for their parents as a dependent, adult dependent family member. But this types of visa is very rare, very less. A couple of hundreds of visa, couple of hundred visa home office every year grant. So this is what he can do, but it's very rare. So I think your answer is no, he cannot bring his mother as a dependent of a point-based system candidate. So all of you who ever watched my program, thank you very much. And I want to again tell you one information. Please share this video because I'm giving you an awareness message. Many people in Facebook group, in different Facebook pages, YouTube, different platform, TV, different media, they are inviting people to make an application. UK Home Office, UK are introducing new point-based system. UK are introducing new work permit. The student visa going to open, work permit going to open from January. Please be aware, this information is not correct. In a sense that, what I'll explain you now. Student visa never was closed in the UK. Student visa right now is not closed. Student visa was open, is open, and will be open. This is the first information. Work permit never been closed. Tier 2 work permit, many of you know, was in place. Right now, still have work permit under Tier 2 general work permit, under Tier 5, under Tier 2 general work permit. The future also will be work permit. So the statement what they are saying that student visa going to open or the work permit going to open from January, this statement is incorrect. Home Office from time to time reform the immigration rules, and accordingly from January they reform the immigration rules again. But in terms of student visa, I don't see any changes rather than 2-year work permit, because the post-study work permit, which was prior to 2012, this was going to replace again. Other than this, nothing has changed. Immigration rules, it was tier 2 general student visa, tier 4, excuse me, tier 4 student visa, that what moved to in a separate appendix, but the rules are same, just it was a reform, that is again they write it in a plain English rather than nothing. Nothing has changed in student visa. Okay, so student visa has nothing changed, same requirement still, the English language requirement. You need 70 point, 50 point will come from your letter of acceptance for study. So from university, if you pay that tuition fee, university will write a certificate of acceptance that will confirm 50 point. Your English language requirement will confirm 10 point, and 10 point will confirm your maintenance, that is you need to keep the money in your bank statement. It's exactly same rules right now, it was last year as well. So in my opinion, nothing we can give a hope that the student visa are going to open or some major changes come. It's not like this in student visa. In terms of work permit, yes, there are some reform, but it is I can say yes that it is a significant reform, that is in terms of wages, salary, which is salary threshold was 30,000, but is now come down to 25,600. A residence labor market test has been removed, a cap system removed. So this is the couple of changes, but other than nothing change or nothing, not a major changes which will open the door of the UK. Europe is closed, open door for new come from Bangladesh, Pakistan, India, Africa, and get replace the job. Not like this. So please don't fall in trap, because many people from overseas want to come to the UK. Many people here in the UK, they want to bring their family member, brother, sister, son, parents, and don't want to pay 10,000 or 20,000 pound to someone and will get in the market. Please be aware. Don't lost your money. Be careful. Before make any decision, go speak with a solicitor. Please, before pay anyone, before do anything, go to the Home Office website and check whether this sponsor is registered with the Home Office or not. Verify your document, verify the company, then make a decision. I hope it will help my dear brother and sister and my fellow followers. Everyone, very good night, and we'll see you tomorrow in hopefully same time. If you have any question, please leave your comment and I will happy to help. Thank you very much. Good night.